Good morning. Welcome to oral argument. Justice Carol Corrigan is not with us today, but I believe the parties have entered into a stipulation to have her hear the matter otherwise. I also want to announce that this is Frank McGuire's last calling of the Supreme Court calendar in his career here as clerk of the Supreme Court. He will be retiring happily and still be a friend of the court. But Frank, thank you for your many years of service, not only to the Supreme Court, but also to the Court of Appeal, the time also when you were a Chambers attorney to Justice Brown. Thank you for all of your service. We'll miss you, Frank. You may call the calendar.
Thank you again, Chief Justice and Associate Justices. It's been a pleasure to work here. Supreme Court of California, sitting in San Francisco on Thursday morning, September 8th, 2016 at 9 a.m. Case number S218497. Centinela Freeman Emergency Medical Associates et al., plaintiffs and appellants versus HealthNet of California et al., defendants and respondents. For respondents, Margaret M. Grinion. For appellants, Andrew H. Selesnick. Case number S117489, the People, Plaintiff and Respondent versus Grayland Winbush, Defendant and Appellant, called and continued to the November 2016 oral argument calendar. Thank you, counsel.
You may proceed on the matter.
Good morning, Your Honors. Margaret Grignot for respondents. One of the primary purposes of the Knox-Keene Act is to provide outstanding health care to patients. A second purpose of the Knox-Keene Act is to lower the cost of medical services. These twin goals adopted by the legislature are competing interests that have been resolved by the legislature in adopting the delegated model of managed health care in California. This model is patient-focused. The patients develop a relationship with physicians who are part of the independent physician associations who contract with the patient's health plans to delegate the medical services and the cost of those medical services to the associations. In this way, the doctors that are the closest to the patient's medical needs are the ones that are making the financial and medical decisions for the patients and thereby providing the best medical care in the most economical fashion. These contracts shift medical services to the independent physician associations. They shift all medical services, or most medical services, including emergency care. The care is shifted together with the costs, and that means that there's a balance, that the doctors who are making the decisions with respect to the medical care are the same ones that are making decisions and evaluating the costs of that medical care.
But by shifting the costs through the delegation contracts, I mean, it's assumed, it is true, there's no dispute that the responsibility for paying emergency room providers, radiologists, non-contracting providers for services rendered to the health plan or the IPA's patient enrollees falls fundamentally and in the first instance on the health plans.
It falls on the health plans except for Section 1371.4E, in which the legislature has decided that as part of this interdependent delegated health system, the health plans can delegate that duty to the Independent Physicians Association. And that's what has happened here. The health plans have delegated the medical services to Levita. And in accordance with the regulations and the statutes, they have delegated those services to a financially solvent independent physician association that was on the list that the department has developed for financially solvent associations.
I'm sorry, I understand. Saying about the Knox-Keene Act and And the regs that implement it and all the interlocking elements of that, is there anything in that scheme that explicitly means to repeal the common law?
The statute does not expressly say anything about negligence obligations of the health plans. It does say that there is no vicarious liability, and in the context of negligent delegation or negligent entrustment, this court has recognized that negligent delegation is a form of vicarious liability. So in the first place, they have set up a scheme whereby the health plans get to delegate their responsibility. And in this court's decision in Quellamane, this court said that as a general rule, when a business entity makes a financial decision in its own interests, it's not required to take into account the interests of third parties. So under the Quellamane case and the Biaconga factors, there is no negligent common law duty imposed on the health plans in this case. So although the statute doesn't necessarily expressly provide for the absence of a negligence duty, the combination of the statutory purpose and the common law indicate that there shouldn't be.
Could I ask you, counsel, so in this scheme, the IPAs, I get all the initials mixed up, so correct me if I mess it up. The IPAs, there is a corrective action scheme, right? In the event that IPAs run into trouble, there is a corrective action scheme whereby there's initial reporting, there's identification of problem areas, there's a development of some sort of remedial plan. This is all made transparent to the department as well as to the health plan.
Yes,
right?
Your Honor.
And the health plan has opportunity to object, revise, modify, negotiate essentially with the IPA to come up with something that is suitable for correcting the problems, and that the DMHC must bless this arrangement ultimately.
The department and the IPA and the health plans work together to come up with a corrective action plan that is approved by the department.
Okay. So I think this is all, the legislature's policy decision supplemented by the regulations. But nothing in this scheme precludes the health plan from essentially withdrawing from the arrangement in the event of a material breach, right, by the IPA. If the IPA doesn't uphold its end of the bargain on the contracts, one option available to the health plan is to terminate the contract. Isn't that right?
It's not a realistic option, Your Honor, and the reason is this. The department plays an incredible role in determining these corrective action plans. And as the department's brief indicates, they encourage plans to stay in the system and to cooperate with the department and the financially troubled risk-benefit organization to bring the organization out of financial problems and resolve the issue and put everything
Okay,
back.
so I guess that is kind of the nub of the dispute, which is how strong is this policy, right? In the sense that it is true that it would appear from the way the statute is crafted, I mean, given how carefully it's been crafted and also the regulations under it, that yes, I mean, the general design is one to keep these interlocking pieces in place because it promotes continuity of care, it's efficient, reduces costs, et cetera. But in the event that there's a very serious problem, I don't see anything in the scheme that precludes, that expressly rules out. In other words, the policy is not so strong as to displace other background obligations, for example, under negligence principles, which is to say, at some point, if the health plan just is in a position to know that the IPA is just not going to perform, the scheme does not require the health plan to persist in this corrective action process.
In the first place, the plans are required once a corrective action plan has been approved by the department. They must obtain department approval to terminate the contract.
Once
Yes.
it's approved. But before that point, if they know that this is, that the IPA is insolvent or mismanaged or whatever, there's no obligation to actually go through with a corrective action plan, is there? From the health plan's perspective.
From the health plan's perspective, in this case, the department approved the corrective action plan. There's a letter that the court took judicial notice of in February of 2008. So shortly after the financial plan shortly after the IPA had financial problems, the department approved a plan. And so from that point forward, the parties are working under a corrective action plan. Secondly, this is not just one plan contracting with an IPA. Here we have 7 independent health plans that are contracting with this IPA. They're all independent. They all have different contracts with different fees and different provisions. And so to say that one health plan, in order not to have tort liability, has to jettison or get rid of this entire corrective action plan in order that it not be sued for negligence. Because every time an IPA has financial problems, the health plans are on notice that the IPA has financial problems. You have indicated that it's a transparent system. They report. The department knows. Everyone knows that they're having
But
problems.
counsel, even you draw a distinction now. You're drawing it between a situation where a corrective action plan has been approved and one where it has not yet approved. So just to focus you on that span of time before a corrective action plan is approved, what are the options of a health plan that recognizes that an RBO or IPA is not performing the function it needs to perform, is not reimbursing emergency physicians for the care that they are required to provide?
Your Honor, first of all, not reimbursing the emergency physicians is a small aspect of a problem with an IPA that's having financial problems. That's a very small aspect, and it doesn't have, and it doesn't take into account all the other players.
Let's assume that the problem's actually bigger. Let's assume that there is quite credible information that the health plan has in its possession indicating that there are very severe financial problems that the RBO or IPA is experiencing. What are the options of the health plan at that point?
The options are to cooperate with the department, and as you will note from the documents and the department's brief, the department puts a lot of pressure on the plans to cooperate, indicates that it's in the best interest of the patients, the health plan's members, to keep these IPAs solvent and going forward for continuity of care. Yes, there is nothing that seems to absolutely forbid the health plan from walking away from the contracts at that point, but it is not something that promotes the delegated health model that the legislature has adopted. It doesn't promote patient care. In other words, these are by and large IPAs that if you work together, they can solve the problems.
So, Ms. Greenwood, I want to take you back to a statute that you read regarding vicarious liability, 1371.25.
Yes.
There's another sentence in that statute, is there not, that states that nothing in this section shall preclude a finding of liability on the part of a plan or any entity connecting with a plan or a provider based on the doctrines of equitable indemnity, comparative negligence, contribution, or other statutory or common law bases for liability. So that seems to me, in response to Justice Cuellar's question, that we're able to look at whether or not there's a common law basis for negligent delegation here, and even a negligent continuation or negligent reassumption of a delegation contract with an IPA when, as alleged in this demur here, the health plan knew or should have known that the IPA RBO was insolvent. So you mentioned the BIA Conja factors, and this Court of Appeal found that the 6 factors were met. So in your opinion, why is that opinion wrong, considering the BIA Conja factors?
Yes, Your Honor. First of all, imposing a duty on the health plans would not further the legislative purposes of the Knox-Keene Act, and in fact would damage them, as the department has made clear in its amicus brief. It's a comprehensive and complex system of statutes. It has a lot of goals, including providing the best possible care to patients at the lowest possible cost, ensuring the financial health.
I don't think no one disagrees with the goals and the policy, but also, while we all agree there's no statutory requirement or obligation on behalf of the health plans to, in this situation, reimburse the emergency service and radiologist providers, nevertheless, the plaintiffs aren't taking that tack. They're taking the tack of there is a common law negligent delegation, negligent continuing or reassumption of an insolvent contract. And so surely the policy of the Knox-Keene Act can't be that health plans are able to delegate to whoever they want, regardless of the solvency of the IPA. So the Biakanja factors focus us on whether or not there is a policy reason for attaching this kind of liability. And so I'd like to hear from you what you think doesn't apply here.
Your Honor, first let's start with negligent delegation. It is actually factually impossible for a health plan to delegate to an IPA that is not on the department's list of financially solvent IPAs. In other words,
Is that the end of an allegation that the initial delegation was negligent? Does that just stop that allegation, which I think is the allegation in this case, that the initial delegation was negligent?
there's two. They're attempting to assert two kinds of negligence cause of action. First, that the initial delegation was negligent,
and your
secondly,
statement that it was on the list of solvent IPAs, is that the end of that allegation? It goes out of the case?
Yes, Your Honor. I think in other words, the health plans do what the statute requires of them, do what the regulations require them. They delegate in compliance with those statutes and regulations to a solvent IPA, and that should be the end of the negligence analysis in that case.
But it seems to me you're extending that principle beyond, I think, where perhaps we've extended it, and I'd like to see if maybe you have some support you can cite for the proposition that if there is a regulatory agency that determines that a particular contract is approved as a matter of what's simply permissible, that somehow that cuts off any common law liability, for example, for negligence.
So, Your Honors have asked whether the Biakanja factors provide some analysis with respect to that. And I would start by saying that a tort duty with respect to delegation would not promote delegation, which is what the legislature wants to happen. And it would discourage health plans from delegating medical decision-making and risk to risk-bearing organizations. If they comply with the statutes and the regulations, and they can be sued anyway and second-guessed, then they have no incentive.
The legislature surely did not have a policy of promoting delegation to insolvent entities or entities that health plans had reasonable cause to know would not perform properly, right? I mean, the only way this system really works is if people work with reasonable diligence to figure out, which entities can perform responsibly, right?
The legislature has addressed that, Your Honor. The legislature has said, first of all, that it has put the department in charge. It has established financial responsibility requirements. It has told the department to monitor those, and in response to that, the department has monitored those and made a list. It has required plans and IPAs to exchange a full breadth of information so that the IPAs and the health plans have all the financial information they need to delegate responsibly.
So assuming all that is done, and we end up at the same place, the IPA cannot pay. Is that the end of the story?
It is the end of the story with respect to any negligent delegation question. I can move on to the second question with whether there should be negligent de-delegation. But the negligent delegation, the legislature has also said, we're going to have the parties disclose this information to each other, and then we're going to let the free market decide what the proper capitation rate is. And I think that's really the essence of what their argument is. They're not really arguing that Levita was not financially solvent. They can't argue that. They know that Levita was on the list and that we complied with that.
But isn't the object of this administrative process to get the insolvent IPA up and running?
Afterwards, Your Honor, initially, when the plans initially delegate to the IPAs, there's a list of financially solvent IPAs, risk-bearing organizations. And the department does not allow a contract between an IPA and a health plan unless they're on that list. So initially, there is no negligence involved in the delegation. Subsequently, and that's what happened in this case, initially there was no problem.
Let me just say here, though, we're here on demur. So we assume the facts properly pled. And plaintiffs pled that these health plans knew or should have known, regardless of the fact that these IPAs had the imprimatur of managed care health because they were on the DMHC list. And in this particular case, what hasn't been mentioned is the overriding factor that emergency service providers and radiologists or emergency service providers are required by state and federal law to provide these services. They have no choice. They have no choice in the matter. And so when the health plan delegates its reimbursement responsibilities to an IPA, there should be great care because these emergency providers don't get paid if the IPA becomes insolvent. And all of the Knox-Keene Act is fine and well for all of its purposes, but there is a dual purpose here, a dual public policy, that emergency service providers get paid.
Your Honor, I disagree with that. The legislature in Section 1317 said that emergency service providers are required to treat everybody who walks into the emergency room, regardless of their ability to pay. The legislature said that in 1317. The legislature recognized that there would be circumstances in which the emergency service providers did not get paid. They attempted to ameliorate that in several ways. First of all, they developed or they set up a fund that would compensate the emergency providers for certain indigent patients. Secondly, they fund Medi-Cal so that Medi-Cal will pay for emergency services through the Medi-Cal. And thirdly, they said that health plans must reimburse the emergency providers, except that they can delegate that. And that delegation is an intrinsic part of the managed care system, and let me explain how that is. You have a system where the IPAs are treating everyone, and that one of the things they've agreed to take responsibility for are the fees or the costs of emergency services. If that's taken away, then the IPAs don't have any incentive to not have people go to emergency rooms. Part of what the legislature was attempting to do was to decrease the cost of medical services, including the overutilization of emergency services. And one of the ways it does that is by incentivizing the IPAs to use preventative health care and make their own physicians available so that patients don't have to go to emergency
So you've explained how this issue you think should be resolved based on how the statute works. But let's draw the following distinction. Let's assume for a moment that you have made a persuasive argument with respect to the initial delegation. But now let's think about the de-delegation question, which I know you wanted to get to. And I want to just see if you can map out the argument you're making now to the Biakanja factor involving moral blameworthiness. Because suppose that I spot you, as Justice Corrigan would say, that it may not be as morally blameworthy to delegate to an IPA or RBO that has potential for financial problems if that RBA or IPO is on the approved list of the Department of Managed Care. But is it morally blameworthy to continue to delegate when there is very clear information that the health plan has indicating quite severe financial problems on the part of the RBO?
It's not morally culpable on the part of the health plans, Your Honor. First of all, the health plans have paid for emergency services. It's not like they're walking away scot-free. When they paid the IPAs the capitation fee, that included fees for emergency services. So those amounts have already been paid. What the plaintiffs are asking is that the health plans pay that again, pay it a second time. So that's the first aspect of no moral culpability. Secondly, the health plans are doing exactly what the legislature and the statute and the regulatory system wants them to do. They are attempting to restore the IPAs to financial stability. And that, by and large, is successful. By and large, these corrective action plans are successful. The IPAs are restored to financial solvency, patients' care is not interrupted, and providers are paid. And that's what you want to happen.
So what responsibility does a health plan have when it receives information indicating great financial problems on the part of an RBO, short of just simply waiting for the Department of Managed Health Care to establish a corrective action plan?
The health plan has the obligation, both statutory and regulatory, to cooperate with the department to come up with a plan. First of all, if the department recognizes that this can't be fixed, then they will cooperate with the department and terminate the plans if that's what necessary. But if it is possible to fix it, or if that's the department's judgment, which it was the department's judgment in this case, then it's the plan's obligations to cooperate and coordinate with the department in order to make that happen.
Counsel, could I ask you a practical question? Wouldn't it be more likely that a health plan would make the process work? That is, this negotiation in reinvigorating the IPA. Wouldn't it be more likely that they would cooperate in that process if they had a financial responsibility? If it didn't work?
It would be less likely, Your Honor. In other words,
Why is that?
If the health plans thought that they were going to be sued by the emergency room, non-contracted emergency room physicians, and any other participant, I should point out, in the entire process, then their answer would be to walk away. I'm going to walk away the minute I get a negative financial report, because then I can't be held liable. Too bad for those.
Let's assume that's true. Okay, so that's the scenario you posit, which is, and I think that's reasonable, which is that if you have a duty, then the health plans will cover their risk by taking some action like this. I guess I'm sort of wondering, back to the Chief Justice's questions about the competing policy aims here. You answered her by suggesting, I don't think you quite said this directly, but you suggested that there's almost like an implicit rationing of reimbursements for these emergency medical services as a way to contain those costs. Do you think that's part of the objective here? You talked about preventive care. You talked about, and we all know emergency services, medical services are very expensive, right? So is that part of it? Is that that one of the policy goals here is not to, have an unlimited spigot, as it were, for the reimbursement of these kinds of costs?
Absolutely, Your Honor. It's actually absolutely clear in Governor Gray Davis's veto message for the amendment that the legislature passed, and that is that emergency care is the most expensive and the least efficient care in the entire system, and that part of the purpose of the delegated model of health care is to limit emergency care and the necessity for emergency care. In other words, if it's possible, either through preventive care or by making the IPA's physicians available to the patients, if it's possible to do that, that is less expensive, it's more efficient, it's better for the patients, and that is one of the goals of the system.
Okay, so your position is then that the churning, if you have this sort of overhang of tort liability, the health plans will naturally correct for that by, in your view, prematurely jettisoning these relationships, leading to what? I mean, I'm sort of tracing this out because it's hard for me to see what the negative consequence of this is. It creates then a market or a space then for more solvent IPAs to enter into these arrangements at whatever fair capitation rates the market will bear, and it will squeeze out those that are insolvent, thereby, avoiding the need for these corrective action plans? I mean, nobody thinks that the corrective action plans are kind of desirable from the standpoint of, any system just needs to have a few bad apples in it. We want to get rid of the bad apples. So why wouldn't the imposition of tort liability, despite, the consequence you mentioned, lead to a more efficient market, which is a market in which you have fewer troubled IPAs?
Your Honor, it leads to a market where there are fewer IPAs and not fewer troubled IPAs.
What evidence is there for that proposition? If there's money to be made in the system, won't someone make that money?
Your Honor, health plans will not delegate to RBOs if they are at risk for being sued anyway. There's just no point in it. The legislature wants this delegated model of health care. The plans cooperate with that. The plans enter into these delegation contracts because the legislature has decided that that's the best thing for patients. This is about patients. And the other thing I want to point out is what we're talking about is not the health plans. The Knox-Keene Act says one of the purposes is to shift costs from, not health plans, from patients to providers. That's what we're doing, from patients to providers. To the extent you impose costs on the health plans, you impose costs on the patients. And the patients are not supposed to be bearing those costs, because when they pay their premiums, they're already paying for emergency care. And if plans have to pay twice, then the patients have to pay twice.
So let's go back to the emergency medical providers for a moment and just encapsulate briefly what obligations you think a health plan has to these emergency medical providers and exactly when they are changed by a delegation.
Your Honor, under the Biaconga factors, let me just do it briefly. First of all, imposing a duty on the health plans would impair the legislative goals in the Knox-Keene Act or the delegated model of health care. Secondly, the plans are not morally culpable because they are complying with statute and regulatory guidelines, and there's nothing, and they are paying for emergency service, so they're not walking away scot-free. Thirdly, the end and aim of these delegation contracts is not the emergency service providers.
Understood. I'm just asking to make sure I understand your argument. And it seems like your argument is that once any kind of delegation occurs to an RBO, there is no more responsibility that the health plan has to the emergency medical providers, as long as that delegation remains valid, correct?
There's no negligence duty, Your Honor. That's what I'm arguing.
Okay. But there's no negligence duty, but is there another kind of duty then?
No, there's clearly no statutory duty. The
Okay.
statute
So there's no duty, period.
There is no duty.
There's no duty.
If those are the two duties, there is no duty.
I
There's no-
understand your argument.
I want to interject to say that seems very contrary to the language in 1371.25, the statute, that, as I read earlier, nothing in this section shall preclude a finding of liability on the part of a plan or any entity contracting with a plan or a provider based on the doctrines of, and I'll just skip to, common law bases for liability. Your argument here seems to say the statute is the end-all, the be-all, there can be no common law basis, but that seems contrary to what the legislature thought could exist here between the lines.
Your Honor, I don't think that's what the statute says. The statute says, first, there's no vicarious liability, and then it says you can have other kinds of liability, and they say things like comparative negligence, equitable indemnity, and I forget what the third thing is. All of these are concepts relating to apportionment or allocation of fault.
Well, what,
so
about
in other words,
what about the phrase common law bases for liability?
and I'm going to mispronounce this word, but eius stem generis. In other words, that section is controlled by the three specific things that went in front of it. So that section has to do with when can a health plan be liable for the acts of its IPA. And that's actually what they're asking here. They're asking for the health plans to be liable for the insolvency of the IPA.
Ms. Grignon, you've gone over your time, but based on all the questions, I'll give you 3 minutes for rebuttal.
Thank you, Your Honor.
No light, but I'm going to start if that's okay.
Yes, the light is wrong.
Okay.
Just
Good morning,
disregard.
Andrew. Good morning, Andrew Slesnik for appellants. This court has a long history of finding a duty of care to persons when those injuries are foreseeable. And finding a duty on behalf of the health plans, in this case, furthers this court's previous pronouncements. I want to start out by talking about a few of, I think, the factual inaccuracies that were mentioned because they're important. The first one is the idea that the CAP, the Corrective Action Plan, was approved by the Department of Managed Healthcare. On page 19 of the DMHC's brief, they say that they did not finalize the CAP. What it seems is that what happened was there was 3 years of negotiations about the CAP, but no CAP was ever finalized. Partly because a CAP, once it's instituted, must be completed within 1 year. And perhaps Levita was in such dire financial straits they couldn't get to the point where they could actually finalize it. So in this case, you had 3 years that the health plans knew, or they should have known based on all the financial information that they were receiving, that Levita was in trouble.
So this is a good case study in a sense. You have those 3 years, okay? I don't know what's going on in the 3 years, but let's assume that people are working in good faith to try to figure out what a solution to this insolvency problem is. I imagine it's a pretty tough judgment call from the health plan's perspective because the statute tells them, well, you got to be a participant in this process, and this is the statutory process that is set forth. We can infer from that that there's a policy preference, right, that this be the way to handle these kinds of problems. And the imposition of a tort duty here would then suggest that the health plan has to, in the background, be thinking, well, despite all of this, despite the statutory preference for or policy for this, I have to make an independent judgment whether or not this IPA is rescuable. How are they supposed to do that?
Your Honor, in this particular case, where when you look at the statutory scheme, the health plans have a continuing obligation throughout to constantly monitor the RBO or the IPA's financial solvency. The health plans are in a good position to do that. They know that, for example, claims are not being paid or not being paid timely. They understand that Levita has tangible net equity issues. It's up to them to decide, because at the outset, they decided to go into business with Levita.
Okay,
But let me extend Justice Liu's hypothetical just for a moment to pick up on this, because it'll help us understand your reading of the statutory scheme to extend the hypothetical. Suppose then that there is a corrective action plan that goes into effect, and suppose that we agree with you that there is a tort duty that may be owed because of negligent delegation or failure to rescind a delegation. At that moment, suppose that the corrective action plan requires the health plan to continue paying capitation payments. At that moment, does the health plan face both the responsibility to continue those capitation payments and also tort liability?
They do, but
And
they
you
have.
don't see a problem there?
We don't see a problem because under the regulations, the Department of Managed Health Care is required that in every contract between a health plan and an RBO, in the event that the RBO cannot meet its payment obligations, those payment obligations can be reassumed by the health plan. So the health plan at any point, if they see that emergency services, which is a statutorily required obligation on behalf of the health plans, if the emergency service providers are not being reimbursed and they see that, then they have a contract that specifically has to have a provision that allows them to reassume it. At any point, they can go to the...
I didn't hear what allows them to what?
Allows them to reassume that obligation. So in this particular case...
Won't they overcorrect? I mean, in the sense that once you ask people to make this judgment by acknowledging a tort duty, the health plan's safest course at the first sign of trouble is to cut and run, isn't it?
From my client's perspectives, that would be good because then they would be paid and paid reasonably.
That may be good from your client's perspective, but that's not the only perspective at stake in the case, right? So we have a statute with lots of policy goals in it, and the jettisoning of these relationships in a sort of overly aggressive way isn't necessarily good for the system, because the argument would be that it creates a lot of churn in the system, there's a lot of disruption of services, and this is ultimately redounding to the detriment of the patients. So although it's good for your client, surely, it's not necessarily good for the system.
I respectfully disagree. We think that this actually strengthens the model, because if the health plans are facing some sort of liability, if they don't properly monitor and oversee their IPAs with regard to emergency service reimbursement and payment of claims, if they have no obligation, they don't really care. But if they realize that the IPA is having problems, they can do a lot of different things. They can pay more money to the IPA. Perhaps their financial modeling has changed. That's an option for them to do, because that's their business partner to make sure the patients are taken care of. Because remember, the patients, they paid their premium to the health plan. And the health plan promised that they would reimburse for out-of-network emergency services. So the patient is being protected in that model. In addition, this whole delegated model is strengthened because if an IPA is having problems, whatever those problems may be, then perhaps the IPA shouldn't be in business anymore. The health plan has to take a hard look at it. The position in their briefs was simply this: at the time we enter into a delegation contract with an IPA, we wash our hands of it. We're done. Yeah.
Why isn't it enough under the regulatory scheme for the department to be the overseer here? Why must the health plan also have independent judgment? Is there something that's known to the health plan or that it has particular expertise that the department doesn't?
Well, the department, when this court invited the DMHC to weigh in on that question, it said that this particular negligent delegation cause of action was not precluded by the statutory scheme.
But
And
it also suggested that recognizing this particular cause of action would interfere or could raise a risk of interference with the efforts that it takes to rehabilitate troubled RBOs. I mean, so it seems to me that there are two positions about what role the department's activities in creating caps and trying to rehabilitate might play here. One is that the department's efforts displace any possible common law duty. The other is that the department's role is entirely irrelevant and the common law duty is, sort of completely independent of it. And then the other is that there might be some intermediate position where a health plan might, in certain circumstances, be able to rely on the department's actions and or instructions with regard to the rehabilitation of a particular RBO in deflecting liability. In your view, is that middle ground possible? And if so, what does it look like?
well, I think the middle ground is possible. This court in Prospect, and there have been other cases as well, have recognized that the DMHC does not have exclusive jurisdiction over many items. They have a certain role to play, but persons who believe that they've been wronged also can look to the courts in certain situations. And I think this is one of those situations. I mean, Health and Safety Code Section 1371.25 states that. I mean, it's the legislature saying we recognize there are going to be certain times where the DMHC has its role, but there may be a role for aggrieved persons to look to the courts.
But you don't think that that middle ground includes any change in the responsibility of the health plan to continue making, for example, capitation payments under a corrective action plan and continue to face tort liability?
Well, they have options, right? Their option is to go to, first of all, as the DMHC correctly points out, they can refuse to be a part of the process for a corrective action plan. They don't have to agree to the corrective action plan. And even after they agree to the corrective action plan, they can still go to the department and say, we have some problems here. We want to reassume certain obligations.
They need the approval, health plans would need the approval of DMHC in order to get out of the corrective action plan once a plan's been approved.
That is my understanding, Your Honor. Correct.
And a corrective action plan is only for a year. Is that what you said?
Correct. According to the Department of Managed Healthcare's brief, it's supposed to be completed within a year. So in this case, we had 3 years of negotiations. The health plans over and over talk about a certain scenario in which, well, they're going to have to de-delegate, they'll have to terminate the contract. Well, they may. That may be their business decision. But there is another route that they do not mention at all, which is they can just reassume their obligation under 1371.4 and make the payments themselves.
That's true, but, okay, so you said in this case, there's no final cap, right?
According to the DMHC's brief, yes.
In the event that there is a final cap in a different type of scenario, your answer to the Chief Justice was that the health plan would need the blessing of DMHC to get out of their obligations under the cap. So at that point, once the cap has been finalized and approved, the DMHC is the overseer and they're the ones in control, okay? In that respect, you couldn't argue then that there's some continuing tort duty post-final cap, right? Because that is clearly governed by the statute. The obligations of the health plan at that point are clearly governed by the statute.
I'd respectfully disagree.
Okay. No, I mean, please.
Yes. So the health plans do not have to enter into a cap. They negotiate. They're part of the process.
No, but once they have, though.
Exactly.
Assume that once they have.
So
yeah.
once they do, things don't stay static.
I see.
The idea that once you enter into the cap, then everything goes perfectly well and smooth, and it doesn't occur. That's not the real world. The real world is that things change. Patient acuity changes. There could be more visits to a particular type of provider that stresses the IPA. They could have a bad outcome. There's all sorts of things that can occur. So the idea that once they enter into the cap, they have no obligation thereafter, they have no liability or responsibility, would belie the actual facts at that particular time. So in an example where the cap is put in place and everything stays exactly the same and the cap is completed.
Are you suggesting then, even after a cap has been put in place, that there could be a duty on the part of the health plan to actually petition the DMHC to get out of the cap? That there's a tort duty that supersedes the arrangement that is provided for by statute?
It doesn't supersede. It's a separate obligation. It doesn't supersede the obligation. At least that's not our contention. So, for example, they may have a situation where during the cap process, they just stop paying emergency service providers who are out of network.
So you answered to Justice Kruger when she asked you about a middle ground where tort liability and the statutory scheme coexist, that a middle ground is possible. How then does the statute and the regulatory framework change any common law duty?
Well, I don't think it changes the common law duty. We're alleging that there is a common law duty.
Well, of course, but let's suppose that the court agrees that there is some common law duty in some instances of some kind. I took Justice Kruger's question to mean if your position is not that the existence of a common law duty simply trumps anything the statute's trying to do, and instead a middle ground is possible where the statute and the common law duty coexist, the question then would be, how does the statute and the associated regulatory scheme affect the common law duties?
And I appreciate that, and perhaps I misunderstood the question. I looked at it more as a issue of the DMHC has certain responsibilities. As a licensee, the health plans have certain responsibilities to the DMHC. Separate and apart from that, they have certain obligations to my clients and other emergency service providers. And so those obligations can be, they can be separate and apart. And while they may be contradictory, it is up to ultimately the health plans to make decisions about which way they want to go.
And that's a helpful clarification, because just to make sure I understand your argument is that the common law duty is there and is not affected in any way by the statute or the regulatory scheme.
Well, under section 1371.25, that's what we conclude.
Thank you.
I do want to talk a little bit about the pay twice argument and the unspoken contention by the plans that that emergency service providers should work for free. On the pay twice idea, essentially the health plans are asking that this court bail them out for a bad business decision. Essentially, they decided to go into business with Levita. They had all the information, they had all the control, they knew exactly what they were getting into. And somewhere down the line, Levita had problems. And despite knowing of those problems, the health plans continued to make the capitation payments. They did not take advantage of reassuming the obligation. They made a business decision. And when Levita went out of business, and they went out of business completely, they didn't go bankrupt. They just turned out the lights and walked out. Once that occurred, the health plans then said, well, we're not responsible because we paid twice. We'd argue under a duty of care, as we propose, that the health plans wouldn't have to ever pay twice. Because when they saw that there were problems and they tried to work with Levita, and after reasonable actions, they couldn't cure it, then they would reassume that obligation and they would pay. And in fact, that's actually what happened in this case. Because when Levita went out of business, the next day, the health plans were responsible for paying the emergency service providers, as the legislature intended under 1371.4.
I'm not sure I entirely follow. So wouldn't there be necessarily be some intermediate period when, the troubles first begin in terms of getting payments to your clients, but before the lights go out, when there would have to be a period of paying twice under your theory?
Well, there'd be a period, but that's a business decision. So when the health plans decided to enter into these contracts, no one forces them to enter into it. They do it so willingly, voluntarily, and intelligently. Those are business decisions that they make. And if it turns out that they made a poor business decision, then they may ultimately have to pay. But certainly in the negligent delegation cause of action, if an RBO or an IPA starts to miss some of its payments along the way, that doesn't necessarily mean that there's negligent delegation. That's a factual question ultimately about whether they acted appropriately or did not act appropriately, the health plan. The other part that health plans do not mention anywhere is the ultimate result of what they're asking for, which is that people who pay insurance, pay for their premiums, who expect to be paid for their emergency service providers to be paid if an IPA goes bankrupt or is financially insolvent or cannot pay reasonably or make any payment at all, then the emergency service provider should work for free. They cite to the Maddie Fund. The Maddie Fund is for insurance, for uninsurance. It's for those patients who have no insurance whatsoever, and it's legislatively mandated and has to be reauthorized. And it's a small part of the emergency service care. They talk about Medi-Cal. Medi-Cal is not really an issue here, but Medi-Cal makes its payments, and there's a statute that says emergency service providers, this is what you need to make. But the idea that emergency service providers should bear the burden of the health plan's decisions is, I think, fundamentally unfair and goes against the public policy set forth by the legislature. This court in Prospect, I think, foresaw that this issue would pop up in footnote 5 of the decision, and expressed no opinion until perhaps after this case is submitted.
What about your response to opposing counsel's argument that the object of the exercise was to reduce the use of emergency services, and doing it your way would increase it because we would be rewarding the continued overuse of emergency services?
So there's no reduction in emergency services because balance billing has been banned in the Prospect case. So people are still going to keep going to the emergency room, and the emergency service providers are going to continue to provide that care. So I think it'll have no effect whatsoever on it. People go to the emergency room because they believe that they have an emergency. And if they have insurance, that's doubly
one
so.
way to regulate that, in the market, I don't mean government regulation, but the market regulation is that presumably people don't want to work for free. And so you would, through this policy choice, ration, right, the number of emergency service providers, thereby, I'm not expressing any view about whether this is good or bad policy, but thereby making it harder for people to access those services. And that is one way to control. That means that people would have to make other kinds of choices, preventive care, sometimes foregoing relief, whatever. But it would achieve the policy goal of controlling the use of emergency medical services.
True. That's true. It would if there's
what
less.
weight does that get in the balance of considerations here?
That'd be true. And then the result would be inevitably there'd be either those specialists who don't want to come in for emergencies because they don't think they're going to get paid, or emergency rooms that are staffed with less physicians or lower quality physicians because there's just not enough money. The reality is that people die and the waiting rooms get more and more crowded.
So the Knox-Keene Act has been referred to, and its purpose is to promote and deliver the best quality health care in California to the users. And I know that the legislature, it's been mentioned, sought to accomplish this by focusing on several main goals. Ensure the best possible health care for the public at the lowest possible cost. Best health care, lowest cost. But there's also a component in the Knox-Keene Act to ensure financial stability of the system as a whole. The system of health care to Californians has to be financially stable, and there also needs to be available and accessible health and medical services rendered. So in some respects, these policies have, at the extreme, very competing tensions in terms of, financial stability means cut and run as soon as your IPA can't make its first payment on an emergency service. However, it also means stay longer, and maybe your IPA can't pay, but then you've now undermined available and accessible health and medical services because we might be rationing emergency services, or we might not have enough of it because professional choices will be made. Emergency service docs don't get paid. I'm going to be a gynecologist. There may be lots of other choices that are part of this policy. How does your position best serve the purpose of the Knox-Keene Act?
I think that partly because the legislature said in 1371.4 that emergency physicians, emergency service providers must be reimbursed directly. The legislature in Health and Safety Code Section 1317 said we need to have a safety net. We need to mandate that anyone can come into the emergency room without regard to their ability to pay and get treatment. And simply this, if there are less, and the health plans, they don't talk about this at all, and for a reason, because that's not their business purpose. The business purpose is not to make sure that there are enough ER providers. Their business purpose is to pay for care and make a profit. That's their business purpose. So that's not something that they consider. But for the people of California, having a safety net is really, really important. And we would argue that that furthers it because we need to have availability. And as set forth in Cunningham, why should the emergency service providers work for free? Because the health plans made a bad decision.
What's your response to opposing counsel's argument that because an RBO is listed in the list of approved RBOs of the Department of Managed Health Care, that changes perhaps the responsibility that a health plan might have for deciding to delegate to an RBO?
Well, I think there's a distinction. One is, and the health plans have tried to maintain this throughout, their responsibility is only at the time of the initial delegation, that they have no continuing obligation. The DMHC in their brief equivocally says they have a continuing obligation. So at the time they enter the delegation contract, we would hope that they would enter an agreement with one that was financially solvent. But the DMHC also maintains lists grading the RBOs on certain financial factors, including tangible net equity, payment of claims. There's all sorts of issues. And so, as at least our understanding, Levita was on a watch list. They were not meeting multiple financial factors. So that's not an approved list. That's just a list, and it gives certain types of information.
But okay, I suppose one agrees with that. There are nonetheless certain RBOs that cannot be RBOs because they're not on any permissible list, presumably.
Presumably that they'd be out of business.
But the point is, you're not ascribing any legal significance, just to be clear, to the DMHC's decision to even allow a contract to go forward with an RBO.
We are not in the course of a litigation. Perhaps that's a factor that the health plans thinks it's something that the trier of fact should consider in determining whether or not they exercised due care when they were exercising their delegation.
But your point is that should not cut off the possibility of there being a tort duty to begin with.
I don't think it would cut it off. However, a judge or a jury might think differently based on that factor. I have no idea where I am on time because my lights have not lit up.
You have 5 more minutes.
Okay. In terms of the moral blameworthy aspect of, I always mispronounce it, Biaganja factors. From our point of view, their conduct is morally blameworthy. The reality is, in a situation like this where they have knowledge, or they should have knowledge, that the RBO, the IPA, is not reimbursing for statutorily required services, and yet they continue to make capitation payments right up to the bitter end. That is morally blameworthy. That they do have an obligation to participate, and I believe that the DMHC, despite some of their policy concerns, does state that they do have these continuing obligations to work with them. That conduct, we believe, is morally blameworthy. The other part of it is that because they do have this control over the system, a control that they alone exercise. Obviously, they have regulatory obligations, but they're the ones who decide to go into business. When their business partner is not exercising the statutory obligations, is not paying their bills, then that's morally blameworthy as well, especially when we consider that this is part of the safety net and the vulnerable position that emergency service providers are in. I'm in a couple minutes early. Thank you very much.
Thank you, Mr. Selznick.
Thank you, Your Honors. Maybe I can use his time. So let's start with
Answer the last one first, the blameworthy issue.
Yes. I fail to see any blameworthiness in this particular case. The health plans, although he indicates that the health plans delegate willy-nilly because it's their business model, it's not their business model. It is the legislature's business model. So the delegation contracts are pursuant to the legislature's business model. That's what the legislature wants the health plans to do, and they do it. They do it in compliance with the statutory and regulatory guidelines. They only delegate to IPAs that are on the list. They comply with all the statutory and regulatory requirements for their contracts.
But then you get to the point where the IPA is unable to pay.
The IPA has financial difficulties, and it's not...
And the doctors are not getting paid. Correct?
And perhaps everybody that the IPA owes is not getting paid. Employees, contracted physicians, hospitals, all kinds of people are maybe not getting paid. But the department has made a judgment that that the plan is subject to rehabilitation, that the IPA is subject to rehabilitation.
On that point, can you shed some light on this factual dispute about whether or not a cap was actually finalized in this case?
In the letter that the court took judicial notice of, it's absolutely clear. On February, I think it's 28, 2008, the department sent out a letter that said, Levita's corrective action plan has been approved, and you're supposed to cooperate with each other from here on out. Now, the real problem in this case with Levita was its financing. It had financing, and it was having trouble getting that financing to stay in place. And so perhaps after February of 2008, things weren't going as well, and maybe there were amendments to the corrective action plan, and perhaps that's what the department was talking about, or when it said not finalized, perhaps it meant it wasn't successful. It's not clear to me, but the record is absolutely clear that there was a corrective action plan in February of 2008. So, from that point forward, at least, the parties are acting under a corrective action plan. Going back to moral culpability. So they're not morally culpable at the outset. They include the cost of emergency service in the capitation payments. Everyone's fully advised of costs when they enter into these agreements. And after the RBO is in financial difficulties, then they cooperate and work and coordinate with the department and the other plans. It's not just one plan. The other plans, the department, the RBO, they cooperate with them to develop a corrective action plan because the department thinks it will work. And if it works, then the patients are helped because they're in the same IPA, they have the same doctors, there's no disruption. So it's a good thing. There's no moral culpability here at all.
Your position is that there really is never a scenario where the health plan is or should be put in a position of displacing the judgment of the DMHC, which, with respect to the rehabilitability, the capacity to be rehabilitated of the IPA.
Yes, Your Honor, absolutely. And who's going to decide that? Is that going to be a judge or a jury after the fact? They're going to second guess what the department has said, and the department has stressed to the plans that they should keep their patients. Let's remember, the reason for this system is the patients and not the emergency room physicians. So the department stresses to the plans that they should keep their patients' health and safety to the forefront of their minds and cooperate with these rehabilitation plans. And so that's what's supposed to happen. And the patients are advantaged if these plans are successful. And the patients will be disadvantaged if the plans are incentivized to walk away. In November of 2000, so after everyone delegated to Levita, it goes on for years, months, however long it goes on, for the first time in November of 2007, Levita starts to show some financial problems. By December of 2009, their lender has gone bankrupt, taken all their money, and they can't be rehabilitated. And at that point, it becomes clear to the department that they can't get any other funds because of the state of the economy at that point, and so the plans terminate with the IPA.
Ms. Grignon, I'd let you finish up, but the time is run, including his time. So 30 seconds, your best argument in 30 seconds.
Okay, thank you, Your Honor. So I would like to say that regardless of whether this court views this case from the prism of a statutory bar or a statutory safe harbor, or whether there is in fact a common law duty of negligence under the Biaconga factors as this court has set forth in Quelimane, or perhaps an abstention doctrine, under any of those theories, the answer should be the same, and that is that the health plans do not owe a negligence duty to the emergency room providers in this case because of the statutory and policy considerations that have been outlined. And thank you for letting me speak.
Thank you, counsel. The matter is submitted. We stand in recess.